Hi, everybody. Welcome to C-Suite. We are just so delighted to have you join the next Zoom that we're doing in this webinar series. C-Suite, anybody new on here? Well, let me give you a quick overview for anybody who is. C-Suite, we're our executive women. We're CEOs, CFOs, COOs, presidents, vice presidents, directors, founders, and what I call women who write checks, women in institutional finance. So venture capital, private equity. I'm in investment banking. Beth and I co-started C-Suite about 3 years ago. We just love working with everybody here. And just, again, thank you for joining us. I will just talk about what Beth would, let me say I can't join us. Beth would tell you about, we have wonderful things coming up. We are going to be doing our New York launch virtually online, which is actually fantastic because then we can invite everybody, not just the women in New York. We are launching a new website shortly, so you can look out for that. And we are just planning our programming into the summer. So with that said, I would like to get us started. We have today as our guest, Rosie. And Rosie is Rozita Yacobi, and she is an attorney. She is going to be talking to us about wills and trusts. And I am actually really happy that we're doing this topic because I think, especially with the virus, everybody should be looking at their wills and trusts and making sure that, you know, if God forbid anything ever happens to anybody, that you and your family are covered. So with that, Rozita Yacobi, Rosie, I'm turning it over to you. Thank you.
Actually, Diane, I'm so sorry to cut you off, Rosie, but we have a couple of things to talk about tech-wise before we dive right into the program. I promise we will get to the main event in just a moment. But for anyone who is a little bit less familiar with Zoom as far as webinars go, I know we're all using them for our regular meetings. But with this type of presentation, we're going to recommend that you use side-by-side mode. Rosie has put together some incredible visuals and a lot of text for you to read. So we recommend that you use side-by-side mode. And I have a little visual up on the screen for how you do that. On the lower left part of your screen, you should see a video icon. When you click on the up arrow next to your video icon, you'll get an option that says View Options. And then from there, you can click side-by-side mode. It should open up a little pop-up box for you. The third option on the left will be side-by-side mode. That's just going to give you the best visuals possible for today. All right, and now with that, please take it away, Rosie.
Hello, everybody. Let me share my screen. There we go. A few years ago, a dear friend, actually she's here, Susie Amami, invited me to one of the C-Suite events, and I immediately felt welcome, felt connection with many of the people that were attending that first event. And it was lovely to see a networking group of women. Because usually when I attend, it's not exclusive to women, or people are not as open and collaborative in their efforts of doing, you know, getting to know each other, their businesses, and sharing information. I just love the organization. And I've attended many of the events over the years and gotten to know a few of the lovely ladies that are there. And I wanted to thank Diane and Beth for inviting me to share this really important topic at this point with everybody. So what I'm going to do is go through the first 10 slides kind of fast. And after that, I'll slow down and go into some of the more details. And we have time at the end with questions, and we can go ahead and answer any questions you may have. So, and there's a few polls that Jenny will come in, and please answer them at your convenience. There's a few of them, not that many. Anyways, what are we talking about? Legal life planning. It's protecting you, your family, and your assets. And by that, I mean, what can we do to help you? So I'm gonna go over again the information, and then after that, for some reason it's not going through. Then we'll move over to the next slide. And many people think of it, oh, it's just a set of legal documents. No, it's not just a set of documents. It's planning and planning for the future in an effective way. What we're talking about is family, your healthcare decisions, making sure you're taken care of the way you want to be taken care of. God forbid you get sick. Asset protection, what we can do, what steps we need to take to avoid probate, which I think is critical for everybody. Avoid unnecessary taxes to the extent possible. Many times we can eliminate or reduce estate taxes. And I'll talk about the estate tax exemption later down the line. And the different types of assets, trust and how it passes. But the whole point of doing all of this estate planning is to make sure you have peace of mind and your family will be taken care of the way you want them to be taken care of during your lifetime and when you're not incapacity or passing. So on the left, that's my family. So some of the work that I do, it's because of my family. I handle a lot of things for my families with minor children or young adult children, and I'll explain that in a little bit. My daughter's 20. My middle son on the left, he's 15, and the youngest, he's 11. And the types of families that I've served, and it's not a one-size-fits-all. We have the traditional families, the single, blended, LGBT, and multi-generational, so they're trying to figure out how to pass assets to the generations after them. And the one thing, again, with healthcare, it's self-care, your body and your choices. And I know it's a topic that's on everybody's mind at this point. What can we do to make sure that our body's taken care of the way we want it to be taken care of in case something happens? Many of you may have heard, not everybody, Terry Scheibe was a lady. And this is why I think healthcare directed is so important. Terry Scheibe had a stroke. She was on machines for 15 years. Government, back then it was Governor Bush, but once he was president, he actually had to sign in documents to allow for it to go back to court to make a decision to release her from her machines. She was on machines for 15 years. So I always tell people, make a decision what you want to do with your healthcare, and it'll happen the way you want. And another facet of what we do is protecting your assets, not just your home or your money, life insurance, where it goes and what happens with it. And for many of my clients, they have a home or they have residential or commercial real estate that they own for income producing purposes. What can we do to protect those assets as well? And again, a topic that's important for most people, it's how to avoid unnecessary estate and gift taxes. At this point, I'll give you guys later on some breakdown of what I'm talking about, estate taxes. And we're gonna have a poll in a minute. How many of you have a plan? And when was the last time you reviewed your plan? So we'll wait for the result of the polls and then I'll go ahead and explain what I mean by that. Okay. It's very typical. About a little more than 50% have a plan, but many don't. So for those who have had a plan, I highly recommend every 3 years at a minimum to review your plan, just like filing taxes. What's changed in your life and making sure everything's up to date the way you want. And for the 43% that didn't have a plan, the state that you live in, which right now most of us live in California, has a plan for you. And I'll explain what that is. As you can see from the picture of a courthouse, it's when you end up in court. And by that, I mean, if you have minor kids, it's a guardianship process. And if you don't have minor kids, it's a probate. Either way, whether you have minor kids or not, it's a process called probate. So basically, it's a lawsuit you file against yourself with your own money for the benefit of your creditors. And what I don't like is that it's expensive, it's public, and it takes a long time. And it's on an average, it takes 9 to 15 months for a probate process, for a simple probate process to conclude. I've had cases that I have to, they were going on for 15 years or longer. So if you want your assets to go to your loved ones without this process, then depending on your circumstances, you may need to have a different type of plan. And what I don't like, and absolutely I tell everybody, the court process for probate is very, very public. You can go down to the courthouse. Right now it's closed, but you can go down to the courthouse and say, I want to see the records of so-and-so. They're going to hand the file to you. So you're going to see how many bank accounts, because it's public and it's available to everybody. If they had a will, what their will look like, what are the assets, because there's a court referee that looks at all the assets and what's involved. You're going to see what this person left for their loved ones. And it's expensive for somebody with just about $850,000 value of assets. And when I'm talking about fair market value of home, I'm not talking about your equity. It's how much your house is worth. And it's set by code how much the fees, the attorneys, the court, and everybody can charge to put the probate process through. It's expensive and it's really not necessary. And I'll explain that in more detail. And the one thing that I think it's really important is how is your family going to receive the assets that you leave for them? Through probate, estate taxes, dealing with creditors, or do you want it to go the way you want? Something I found that some people rely on, common estate planning techniques that don't work. They hold property jointly. So they say, oh, after I pass, it goes to them. They don't realize that half of it is still going to have to be probated. Or designating a beneficiary. Yes, for life insurance, it makes sense. But if you designate a beneficiary, let's say, saying my spouse, and then my kids, and your kids are minors, the court's going to get involved and figure out what happens with that money until your kids are 18. Or some people think just signing a will is enough. And in many circumstances, it is not. So minor kids, I think a poll is going to go out. How many have minor kids or young adult kids? And by young adult, I mean anybody over 18. Okay, so 27% have minor kids or young adults. So I'll go over the next few slides a little faster. If you have minor kids, for the short term, God forbid you don't come home one night, the babysitter calls the police and Child Protective Services gets involved. And if you haven't left a plan at all, there is a plan, but you're not going to like it because a judge makes a decision about you and how your children are going to receive the assets and when they're going to receive it and so forth. So for most of my clients, the ones with minor kids or with young adults or anyone else, we set up a family emergency card that they keep next to their driver's license in case they don't come home. You know, they get in a car accident, they're not well, who needs to be called? For my clients who don't have minor kids, what I do is I put the healthcare directive on one side and the durable power of attorney on the other side, meaning who can step in, take care of the mortgage payments and all the other stuff in case somebody's incapacitated. And it could be temporary incapacity or long-term incapacity. And for young adults, this came on my radar a few years back, how important it is to protect them the right way if you want to continue helping them with their legal and medical affairs. My friend's son, she had twin boys. They had gone to BU in Michigan for college. I don't remember which one got sick. He was in the hospital and she called me. She's like, the roommate's called, he's in the hospital. I need help. How do I get access to talk to the doctors? They're not talking to me because he's not completely in a coma, but he's not able to communicate with me. What do I do? Because of HIPAA laws and privacy laws, you will no longer be able to assist your young adult children. So if you want to continue helping them, and I've done this for my daughter and many of her friends, is to make sure that you have the right documents in place. And by that, there's 3 documents that are critical for young adults. It's a financial power of attorney, the HIPAA to be able to speak to the doctors, and the medical power of attorney. And something that I'm always concerned about is having kids inherit money too early. Let's say you have a will and your kids inherit money. When are they going to give it to them? Court is going to give it to them at 18. Would an 18-year-old go to college and get a degree when they've received $2-3 million of life insurance and home and assets? Probably not. And I've seen scenarios like that. One of our relatives, his wife, she had inherited $2.5 million when she was 19 when her mom passed away. By the time she was 25, right before she turned 25, she didn't have a dime. So I think it's really important to set up things at an age where they're able to receive it, or set up asset protection. But I always tell my clients, children under 26 don't have a capacity to do this. They can make uninformed decisions because the frontal cortex is not developed fully. Give it to them after 26 if you don't want to set up asset protection for them. So I'm going to dive in and give you guys a little bit more details in terms of the tools and what my suggestions are for different scenarios. What we're talking about is asset protection. We're talking about charitable giving, which Jenny's familiar with. Transferring wealth, business succession applies to some of us, and taxation, how to reduce estate taxes and what we can do to over long term to plan ahead. And how much protection you need. Again, it depends. Not everybody has minor kids or young adult children. So the protection you need is different. Healthcare, everybody has different healthcare wishes. Estate tax considerations, assets, or different considerations. Each family, again, has something different that they have to be concerned about. And if you want to protect your assets for the next generation, what do we need to do? And it's not super expensive at figuring out how to pass it to the next generation. So what I recommend for anybody whose assets are over $150,000, that's in California. If your assets are over $150,000, you're going to end up in probate court. So what you want to do is make sure that you have a fully funded living trust. I've seen many trusts that come my way for review, and their assets are not in the trust. So it's basically an empty shell. It's an empty box with none of the assets in it. Making sure all your assets are titled properly, making sure your life insurance is titled properly. And for many, what a situation that I commonly see is when they have, for example, they set up the trust 10 years ago. Their home was in a trust, but they refinanced it 5 years ago. They forget, most people will not know that they're supposed to put it back in the trust. Therefore, again, that property is going to be subject to probate, and it can be avoided with the right planning and the right documents in place. Now, the different types of trusts. We have 2 major kinds, and within that, there are all these subcategories. We have the revocable trust that can be changed throughout your lifetime. And in some situations, I have had clients where they set up irrevocable trust, meaning you cannot make changes. You will no longer be the trustee of it. And until a few years ago, you couldn't at all make any changes, but now they allow it with limited, under very, very limited circumstances. It's a great asset protection vehicle, but it doesn't work for everybody. So depending on your circumstances, you can figure out what's needed. The one that's used frequently by a lot of people is the ILIT, which is the Irrevocable Life Insurance Trust. And most people would set that up to pay for estate taxes that are coming down the pipe. So determining if a revocable is better for your irrevocable, it depends on you, how you want your loved ones to receive it, when can they receive it. Right now, as I mentioned, estate taxes before, each person has a coupon of $11,580,000 that they could pass to the next generation without estate taxes. But anything over that $11,580,000 gets taxed at 40%. For a couple, when they're setting it up in the trust, it becomes 23,160,000, and it's really advantageous. The only problem with these numbers is that it's supposed to change on December 31st, 2015. So we don't know yet. Some people are speculating that it may go down. Historically, it has never gone down, but we don't know because it's really high right now at this point. And for some people, I know that they have special needs children, and to me, I've dealt with scenarios like that, and what we can do to help is making sure that the person that has special needs children provides enough resources. It's your responsibility. Get a life insurance or set aside enough money. Have a special needs plan and consider inflation, taxes, and stuff. The person who are going to be taking care of their special needs children are not responsible for the financial needs. So making sure everything you set up, your asset protection, and maintaining the government programs that your child with special needs will need, that's really critical. And then pets. Many of us have pets. And this became really important to me when a few years ago I had attended a continuing education, met this lovely lady. She called me 2 weeks after. She said her roommate's boyfriend, tragically at the age of 27, 28, got in a car accident, passed away. The mom of the boyfriend went and grabbed the dog, gave it to a kill shelter. She was just overwrought. You know, she was distraught, didn't know what she's doing. The girlfriend got the dog, brought it back home. Then the mom realized that last thing she has of her son is that pet. So they got in a lawsuit as to who owns that pet, who should be taking care of that pet. So if you have pets and you want to make sure someone's taking care of them, make sure there's a special provision in your trust addressing your pets or successor pets. This one again came on my radar because somebody had a gun, one of my clients, and it's they're a vet, and they were saying the wife, they were both actually Army vets, and one of them, the wife didn't have guns, but the husband did. So the issue became, what type of a gun do they have, and what considerations we need to think about. So for example, in the middle of the page, you see, if you inherit an IRA, you make a mistake, you're dealing with taxes, not a problem. But if you inherit a gun collection, that could be a problem. You could have felony charges there. So anybody who has a gun, you need to figure out which type of gun and do you need a gun trust. So for those who own real estate, there's a lot of lawsuits that are filed every year. Making sure that there's inside liability and outside liability in terms of what happens and what type of protection you'll need. Real estate is a hot asset, and hot assets need to be segregated as much as possible. I'll go through the next slides really fast. This is for somebody who owns commercial real estate, putting it in LLC and protecting it and segregating it. And now, sorry, I'm going to go a little faster. Estate taxes, right now it's at, again, as I mentioned, 11,580, and then 40% above that is going to be subject to estate taxes. And something that is really important is bank accounts. Right now in the state of California, the last I heard is 8 billion, but they told me the number has risen. People forget their bank accounts. Your grandmother may have forgotten about a bank account that's in there. So you need to go find out and make sure it's titled. So for my clients, to make sure none of their assets end up in the state controller's office, we have asset spreadsheets and we maintain it annually. They go ahead, after they file their taxes, they go through it and see what accounts they have, what has changed, and making sure everything's listed. And this is something that's very dear to me. It's legacy interviews. I believe Jenny's going to do a quick poll. And I will explain what I mean by that. A few years ago, my father passed away. And my son was playing with my phone. He erased his last voicemail. The last voicemail I had of him saying, "Rosie, I miss you. I hope you have a great day. and so forth. At the time, he was like 3 years old, and I was devastated that I lost his voice. Yeah. So this is not so much the legal documents, it's capturing stories, insights, everything that you want the next generation to know. So I've done it for my kids. I've already done 2 legacy interviews. So I'm building a library for them. Many of my clients, I have 27-year-olds to 80-year-olds that are doing legacy interviews for the next generation. That's who they are and what's important. Assets they'll take, but the stories, their voice, their expressions, everything gets lost when somebody loses capacity or they're no longer here. So I highly recommend it. You can do it in the comfort of your home. I can send in a camera crew or just give you the questions and have you do it yourself. But it's important. Pardon me. So the typical estate planning experience, as many of you may know, they set up your trust. They never got in touch with you. And some do. And making sure, you know, they set up your documents, you're on your own. For those of you who haven't seen your attorney, call them, say, hey, can we have a review? And for those who don't, I'll tell you what's the way I do things. I educate my clients, make sure they're making informed decisions, save them thousands of dollars in probate, protect their money from the outsiders, getting to know what they have, protecting minor children, making sure that if you have young adults, how to help them, and keeping families out of court and out of conflict, and making sure your plan will work when you need it. So a lot of things I cannot address other people's work, but I can do it myself. I've seen a lot of do it yourself that they've brought to me to review, and it's a disaster. And then I have actually working on a trust right now. They had set up a trust for this person, but there's no durable power of attorney. So in case of incapacity, she's let's say in a hospital for a while, no one has the authority to go in and help with pay her mortgage, pay her electricity bill, or any of that. So some of these attorneys, cheap lawyers, don't go through it and set up everything the right way. And to me, that's not acceptable. Anyways, I bring peace of mind. It's my goal to see what I can do to help, what I can do to bring peace of mind to the person in terms of making sure all their documents are in place and it's handled the way they expect it to be handled. So the way I do things is we start with an hour and a half. It's a working hour and a half, getting to know what you want, what your wishes are. And it's not super expensive, depending on what you need. My clients decide in advance their own fees, what type of protection they need. Based on that flat fee, we'll make a decision for them. But it's an hour and a half, and they have homework to do in advance. So for everybody that's here, if you could email Elizabeth@yacobilaw.com, she will give you a $750 certificate, which is for estate trust and legacy planning session. It's an hour and a half to 2 hours of planning and seeing what you need, having you make informed decisions. And then for anybody who wants to make an appointment, I'll be happy to I'll take a limited number of appointments only for the month of June. Contact her by June 12th, and she'll give you a $250 certificate towards any type of trust or wealth plan you decide to do. And making it easy and having you make informed decisions as to what you want. And now I'm going to open it up to questions. Sorry, I went through a lot of stuff. Anyone has questions?
This is Jenny. I just wanted to jump in and let everyone know that your chat function at the bottom of your Zoom screen, feel free to drop in any questions there for Rosie, and she can see them.
Oh, what happened to my screen?
There you go. We see it.
Okay.
So Rosie, I have a question. When you talked about the pets,
yes.
Should you leave money with that as well?
Yes, I do. I recommend, depending on how much cash available. I would say a few $1,000s, depending on how old your pet is, for the person that's taking care of them. And there's two things you can do. Some people just leave enough money for the care of the pet, like their vet bills and food and stuff. But I have clients that leave compensation as well. It could be a few thousands or as much as hundreds of thousands for the care of the pet, compensation for the person taking care of the pet. Any other questions?
Thank you.
Welcome.
Rosie, it looks like we have a question from Veronica that says, for life insurance policies, should the trust own them? And if so, do you leave the policy beneficiaries to your spouse or to the trust?
What I usually do, I like to set it that the primary beneficiary is the trust. And then the secondary would be the spouse and the children. And the reason I say that is sometimes in my trust, I set up asset protection for their children. So if you give them the money directly, let's say a $2 million policy goes directly to the kids, you lose that asset protection feature that was set up in the trust.
Okay, can I clarify a little bit? There's no kids involved, it's just a spouse.
If it's just the spouse, then it depends. Did you want asset protection for the spouse? And by that, I mean, you can protect the surviving spouse in terms of from creditors or future divorce or anything like that.
I suppose yes. Protection's always good.
Yeah.
So then you put it in the trust. Either way, she has immediate access to it, correct?
Yeah, they'll have access to it for health, education, maintenance, and support, or however way you set up your trust. I've had situations where they're leaving it everything outright to the surviving spouse, but I've had situations where they're saying, no, I'm going to set up, I'm going to require my surviving spouse to either get a prenup or get a co-trustee so the funds don't get dissipated in case they get divorced. And I've seen situations where the surviving spouse gets remarried and their next spouse is like using all the funds. And then when they retire and again, they get divorced, they don't have the means to live comfortably.
Okay, thank you.
You're welcome. Any other questions? Let me check. Oh, okay. I'm gonna read a few of the questions so I can go ahead and answer. Sorry, it was, yeah, employers can search public records of your financial information. Everybody can. If you go down to the courthouse, anybody's filed any type of probate, you can go ahead and see who inherited, how much they inherited, and where the funds came from. Should the trust, should you own real estate with your parents? No. And let's say, for example, you get in a car accident and they put a judgment. So the house that your parents are supposed to live in, they won't be able to live there if there's a judgment on it. You can take over the mortgage and the deed. You have to file certain documents and you have to be careful because many times it can get reassessed. So the paperwork needs to be done correctly. So when you're transferring the assets, so let's say your parents are transferring their shares of the asset to you as a person, making sure that it's set up properly so the property doesn't get reassessed in terms of taxes. Any other questions? I'm trying to think. Half goes through probate, yeah. And probate, again, it depends on what your situation is. Sometimes probate can be handled within 1.5 years, but in many cases it can drag on for a long, long time. And I personally do not like the probate court at all. If you have time, once the courts open up, right now they're closed, you can go to court and see what's happening in there. I've seen situations, a lot of different situations over time. And once in a while, when I have a free day, I'll go in and just sit the proceedings as to what's going on, making sure, parents, if, in case they lose capacity to make decisions, do you have authority to help them, or do you need to go through the conservatorship to get it over them? Or if they have set up things, documents properly, like the durable power of attorney is set up correctly, you won't need to go through the conservatorship process, and you'll be able to assist them with their financial matters.
So Rosie, I did want to say that your offer is very generous to the folks that joined, and so we thank you for that. That's just fantastic. And I'll also say, my mom passed almost a year ago, and I retained a lawyer right away to protect my husband and I as we dealt with her estate. And that was one of the best decisions we ever made.
Yeah, trying to navigate some of these ever-changing laws and the court procedure, it's not easy. Even for attorneys, for us, I'm constantly taking continuing education classes on how things are shifting, and different courts have their own way of doing things. Which court were you in LA or?
No, she was in Tennessee, so we retained a lawyer from Tennessee because their laws are different, right?
Yeah, completely, yeah.
Laws, and we had no idea what they were. So that's why it was a great decision to do that. And so it helped us tremendously because we wanted to make sure we weren't liable because there were siblings and other things that were involved.
Right. So as a trustee or executor, it's always a good idea to have an attorney involved so they can guide you so you don't make any mistakes. And then some states, I noticed, I don't know about Tennessee, but some states are we call them probate friendly states. California is not one of them, regretfully. There was one probate I was involved with before I had my daughter. After 15 years, and I had my second child, I couldn't stay on that case anymore. And it went on for longer, a few years after I even excused myself from that case. So sometimes it becomes really, really, really lengthy.
There is a question in the chat, and it says,
right.
How are assets other than real estate, such as private equity investments, handled?
It depends how it's structured. If it's structured as an LLC, the private equity investments, or is it directly under your name, how it's handled, it depends on how it's structured. Can you give me a little bit more details about how it's set up? Is Lee still here? Okay, here we go. Okay, perfect. So if you have a trust, the best thing is for the LLCs to transfer the shares of the LLC into the trust. So it's called assignment of interest. So if you work with an attorney, you can call them and say, listen, I have this particular asset. Can you please make sure it becomes a trust asset? And then depending on what they set up. So for my clients, I not only set up the trust, I also do two other documents. One, it's called a declaration of trust. One, it's called assignment of personal property. And I cite to codes and say, no matter what assets I have anywhere, I need you to consider it as a trust asset. With real estate, it's a little difficult. We have to file a HECSTAT petition, go to court and get it approved. But even with that, with my declaration of trust, the second I call them my insurance documents, I make sure these assets are considered as trust assets. So we will avoid a full probate and make sure it gets transferred into your asset and becomes a trust asset. Any other questions? No. Okay. Diane, would you like to take?
Yes, Rosie, that was fantastic. Thank you for all those wonderful insights. For full disclosure, as soon as we set this up, I actually set up an appointment with Rosie for August because, again, my stuff is from when my kids were pretty much born. So, and they're in college now. So I thank Rosie. What can you do, right? You get to it when you get to it. It's been busy. So thank you for your very generous offer and for your contact information. I think if anybody wants to stay, why don't we just open this up so that everybody can kind of talk to each other? If anybody wants to, make their videos active. Thank you, Rosie. Actually, let's do a big round of applause.
My pleasure. My pleasure.
That was fantastic. Thank you for the work you put into that.
My pleasure.